In this seminar, which is going to be about an hour long, it's going to be focused on the most recent developments. So first of all, I'm going to look at the new legislation following the coronavirus pandemic about the remote witnessing of wills. Next, I'm going to look at some of the recent cases from 2020 and more recently than that, involving contested probate, so disputes about whether a will is valid or not. I'm going very briefly to look at some of the recent changes in procedural rules, more to flag up that there have been changes rather than to dwell on them. And finally, I'm going to review some recent cases that aren't about the validity of wills, but are about the other kinds of disputes that can frequently arise where an estate is in question. A delusion is obviously not just something the testator happens to believe that happens to be wrong. That could easily be an innocent misunderstanding or something that deceased has been deceived into believing by someone trying to slander someone else. A delusion is defined in psychiatry. I understand that this paragraph on the slide is a quote from Judgment in the Case describing the expert view. Described as a fixed false belief of morbid origin, which is inconsistent with the believer's educational or cultural background. And the expert was asked to elaborate on this. And in particular, the term fixed in this context means that the holder of the belief is not open to persuasion, even if presented with evidence to the contrary. So one might draw an analogy with conspiracy theorists, for instance. Another practical development is the various kinds of application, usually by way of summons in probate context, where parties have a choice. They can either commence them in the family division in the probate registry or in the chancery division. And it used to be that the family division had some judges, or at least one in recent times, who specialised in probate matters. That turns out is no longer the case. The particular judge in question retired. And so what tends to be happening is that applications in the family division are being transferred to the chancery division. So what I would suggest is that if it's something that can be done in the chancery division, that's probably better. It'll probably save time and minimise the risk of things getting lost.